All right, well, let's kick things off by looking at our agenda for today. So first I'll be introducing our speakers. Then we'll be taking a broad look at some of the key topics in today's regulatory landscape. Then we're going to look specifically at what lending organizations could and should be doing to get ready for Regulation F to become effective, that is. Then we'll wrap things up by summarizing the key takeaways from today in a lightning round, and then we'll open it up for Q&A. So without further ado, here are our wonderful speakers. Kelly and Katie, thank you so much for being with us today. So Kelly Nepper-Stevens is Vice President of Legal and Compliance for TrueAccord. Her work focuses on government regulation, compliance, and civil litigation. Kelly serves on the board of directors for the Receivables Management Association International and is an ACA certified instructor and is on the steering committee for the Consumer Relations Consortium. She also served as a small entity representative, or SIR, for the arbitrations and debt collections rulemaking. Her podcast, Two Indebted Attorneys, can be found on Podbean. And Collection Advisor magazine named Kelly one of the 20 most powerful women in collections in 2018 and 2016. Katie Neal serves as TrueAccord's Associate General Counsel. Katie is a well-known attorney in the industry and has served in leadership positions with the Consumer Relations Consortium, including membership on the CRC's steering committee and as the inaugural chair of CRC's Legal Advisory Board. Katie was also heavily involved in advocating for the industry before federal and state regulations in several initiatives, including commenting on the CFPB's proposals, such as Regulation F, and also smaller initiatives through the CRC designed to bring regulators, consumer advocates, and industry to the table to educate each other and find mutual solutions. Prior to joining TrueAccord, Katie was the general counsel at Inside ARM. So welcome to you both. Kelly, I'm going to hand the mic over to you. Before we get into the meat of today's session, I would love to have you introduce TrueAccord's Legal Audit and Compliance Department and talk about your vision and mission.
Sure. Thank you so much, Lauren, and thanks everybody for joining. As Lauren mentioned, if you have any questions as we're going through our materials today, please feel free to throw them in the chat and we will get to them. Make sure to cover them, and if we can't answer them today, we'll definitely get back to you with an answer before the end of the week. So our legal audit and compliance teams are all unified under one sort of division or department at TrueAccord, and our mission is quite simple. Our goal is to enable the success of TrueAccord through solution-oriented services while maintaining a business mindset. So our clients are not only the clients that TrueAccord services and the customers that TrueAccord interacts with, or the clients of our clients, but also our internal departments, right? Our product teams, our client success teams, to make sure that we are giving them the most up-to-date information on legal and compliance topics so that they're able to do their job to the best of their ability. And so each of our divisions that are kind of unified in one department all have their own separate missions, as you can see outlined here.
Wonderful. Thank you, Kelly.
Yep.
So let's get into it. First, we're going to start by talking about today's regulatory landscape, taking a 10,000-foot view of some of the key issues that are affecting lending organizations. So Kelly, I'm going to hand it over to you to talk about it and to give everyone a preview. Here's some of the topics we're going to be covering today. But Kelly, the mic is yours.
Thank you very much. So, you know, when Katie and I were prepping with Lauren for this webinar, and she said, why don't you give a little bit of a lay of the land of the regulatory place that we're in debt collection, this industry is always in a place of change. It seems like there's never a state that isn't considering new legislation that's going to impact us because of the data that we have, or the activities that we're doing, or the methods by which we're communicating with consumers. So we're never bored in legal and compliance, that's for sure. And there's always something new and exciting to be talking about. So last week, actually 2 weeks ago now, the California Department of Financial Protection and Innovation had its very first Consumer Advisory Board meeting. The DFPI was started a couple of years ago as a part of, some of the California privacy regulations that were coming out to supervise and oversee areas of financial services. And that meeting, which was held, I think, July 27th, we had our own founder, Ohad Samet, serves on the advocacy board. Now, the department has a mandate from the citizens of California, and they've been acting in that way. Even their press releases talk about it. I mean, one of their first press releases came out and addressed how they were issuing civil investigative demands of some major, very large call and collect debt collection agencies, and they're very public about what they're doing. And in talking to folks that are undergoing these, and in talking to attorneys who are helping folks with these civil investigative demands, we've learned that this department really has a very broad view of their oversight and enforcement powers, and are even, asking questions about consumers that live outside of California, because any practice that impacts any consumer could impact a consumer that is in California and in their jurisdiction. So we are super glad that we have the inside scoop with OHAD sitting on this board. And we're glad that we get to share information with them about digital debt collection and about consumer researches and consumer preferences that we know and experience through the communications that we are having with California consumers and consumers across the US. So California has been doing some rulemaking too. We now have to have a debt collection license in California. That takes effect in January. You have to have a license. The rule came out a couple of months ago. It's not official yet. We do have to apply through NMLS, that system, and they say that the application will likely be available in September or maybe later in the fall. We can continue to work even if our license hasn't been granted. So while the license is pending, you are permitted to continue collection activities. So we do know that much from the state of California. And we also know that the licensing law impacts not just debt collection companies, but other financial service providers. So you want to make sure to check that out if you haven't yet. And the way in which the department is running now may change as a result of what's happening with the recall election in California. So if Governor Newsom does get recalled, then there's a vote that's going to happen in the fall. And essentially the ballot's going to be like, do you want to recall Governor Newsom, yes or no? And if you vote yes, then you go choose who you want to replace him. And so if he gets replaced, it could change the makeup and the layout of the DFPI and what they're doing. So
yeah, and Kelly mentioned something very interesting earlier, is how everything in this industry is constantly in flux. And a great example of how in flux and how quickly in fluxes can be is the DC emergency law that came down just last month. So on July 13th, so yes, that was less than a month ago, the DC Council issued an emergency law governing debt collection that was very, very restrictive. It put a lot of requirements on debt collectors. For example, before even communicating with the consumer, debt collectors have had to have 24 months worth of statements for the consumer. They had to have had all the documentation for the purpose of verifying the debt. And then in the initial communication, or rather within 5 days of sending that initial communication, debt collectors were required to, or were going to be required to, send all of that documentation automatically to the consumer, as opposed to the current process under FDCP where the consumer can request the documentation, but the debt collector doesn't have the requirement to send it until that request comes in. The emergency law in DC required that that be sent automatically. And as you can imagine, that is extremely difficult. And the law was going to be implemented on October 1st. But then within a couple of weeks, so on, I believe it was August 3rd, earlier this month, all of a sudden the DC Council amended this emergency law after a lot of lobbying efforts by the industry, so that it pulled back on some of those requirements. Some of the requirements still stand. So collections in DC are probably going to change if the mayor signs this law. But for example, no longer will a debt collector need to collect 24 months worth of statements before they communicate with the consumer, because I mean, at times there might not even be 24 statements. Instead, it was amended to, okay, so you just need a charge-off statement now and the most recent statement, which is a lot easier to work with. And then another change that happened in the amendment, for example, is instead of having to automatically send all those documents to the consumer, you now have to include a notice similar to what the FDCPA requires, telling the consumer how they can request that documentation. So they've pulled it back a little bit, but remember, this all happened within a month. And the very interesting thing about all of this is that this occurred in DC, which is one of the very, very few states that issued a flat out collection ban during the pandemic. And very shortly after issuing this emergency law, they extended the emergency order banning collections, I believe, till October it is now. And there's some thought within the industry that this was the DC Council's way of kind of prodding to see how far they can go with these regulations without public comment, because that's the other very interesting thing about this. This was put forward as an emergency order, straight from the council, straight to the mayor's desk, with no public comment, no public input. So it was a little bit of a shock, but that's just an example of how quickly things change. It's not on the agenda here, but I think it was Nevada had a medical debt law that came into effect too, that they issued notice about it, I think a month before it became effective. So the really great thing about partnering with a company like True Accord is that Kelly and myself and Ohad and the rest of our team, we're so looped into what's happening in this industry that we're staying on top of it, and we know what these requirements are, so that, as Kelly said, we can advise our business partners within the industry as well as our accreditor clients to help everybody fall within this system and be nimble enough to be able to comply with all of these requirements.
I was absolutely thinking about Nevada as you were talking about DC, because as a result of the pandemic, we've seen a lot of changes that have come out, and much faster than we've seen before, right? So the debt collection rulemaking, I mean, that got started with the ANPR, the Advanced Notice of Debt Collection Rulemaking. It came out in 2012, and we finally got the rule that's going to go into effect on November 30th of this year. So that took such a long time. But the Nevada law, the DC emergency law, and all the emergency laws that were passed over the last year in response to the pandemic, and as you know, both businesses, right, are having to address having employees physically present in the office, and then, you know, collection efforts being, temporarily stopped by different legislatures across the country, has been super complicated to keep on top of and make sure that you are, knowing when they end so that you can resume collection. So only recently were we going through all the DC orders trying to figure out, hey, when does this actual ban on collections end, to find that the mayor of DC said, okay, well, we're just going to continue it indefinitely until I tell you that the emergency is over, which happened just in July. And meanwhile, Congress hasn't taken a break, although sometimes it seems like Congress can't get anything done. They have been making progress, if you consider it progress, with the Trace Act. So that passed a year ago. And essentially it is targeted at robocallers and at helping consumers block calls of unwanted businesses. But it's not supposed to be legitimate businesses that are getting blocked as a part of the Trace Act. It's really supposed to stop those marketing communications that are unwanted by consumers. The problem is the way in which it's being interpreted by the carriers as they're implementing the Trace Act, and the stir-shaken provisions have resulted in the ability of consumers to block legitimate calls, such as debt collection calls, and that's problematic because our right party contract rate is going to continue to decline. And this year we also found, as it relates to text messaging, that T-Mobile came out and said, yeah, we're just not going to issue short codes to anybody who's in the business of debt collection, right? T-Mobile just said they were going to block that. And I think there's only a couple of providers that have been able to get exceptions to that. And so it's very, very tumultuous times in trying to make sure that you are reaching consumers. Another big issue that's being passed through a lot of the state legislatures that you have to keep your eyes on are the data security provisions. So Virginia signed into law in March a new data security. It's called the Virginia Consumer Data Protection Act, very similar to the California Consumer Protection Act, as well as the California Privacy Rights Enforcement Act. So California took the lead and passed 2 laws a couple of years ago. Now we have Virginia following suit, and it's the same sort of provisions where a consumer has a right to know what information you're collecting, has a right to request deletion. Of course, that debt collection is exempted from that. And consumers also have a can request to opt out of the sale and marketing materials. Virginia went a step further and is actually requiring that you conduct data protection assessments. So this law takes effect this January of 2022, and there's no real frequency in the statute or real definition of what a data protection assessment is. Is it a full-fledged external audit by someone of your information security regime? Is it, your quarterly penetration testing? It's really kind of unclear from the statute. But it is now a law and it takes effect next year. Colorado also this July came out as the 3rd state enacting the same provisions similar to California and Virginia, with the right to know, the right to correct, the right to request deletion. And as a debt collection company, you must respond to that consumer's request. California, Colorado, like California, it has a 45-day response period where you need to respond to the consumer. And so fortunately, when we built out the True Accord plan for the California Consumer Privacy Act, we went ahead and just applied it across all states so that it was a very easy process to be implemented by our agents and by our code-based compliance system, so that when that request comes in from a consumer, we can provide that response, which is largely a recitation of our privacy policy around how we use that information, how we share that information, and when we delete that information. Speaking about sharing information with third parties, Katie, do you want to talk about the 11th Circuit and their activity this year?
Yeah, so it's interesting that we were just talking about how some things change so rapidly within this industry and you need to be super nimble and act very quickly. This is an example of where pumping the brakes is important despite the natural impulse to want to do something. So the 11th Circuit earlier this year came out with a decision in the Hunstein case, where I'm sure many of you who follow the collections industry have heard. The Hunstein decision basically said that sharing the debtor's information with a mail house vendor is considered third-party disclosure because it doesn't fall into one of the enumerated exceptions within the FDCPA, and the consumer never authorized that disclosure. It caused quite a stir within the industry because it's an 11th Circuit case. It's a Circuit Court of Appeals decision. Those are big, right? Well, no, there's a saying in the legal field, and I think Kelly said it's written somewhere in the Supreme Court building, the US Supreme Court building, that the wheels of justice move very, very slowly. And this is a perfect example of that. So yes, there is this 11th Circuit case that says this. There are some underlying reasons why we think that it may or may not be a solid decision, and there are currently the decision is currently under review by the 11th Circuit to determine whether or not they want to grant en banc review, which means when a Circuit Court of Appeals decision comes down, it's usually decided by a panel of 3 justices. The en banc decision means it's decided by the entire panel of justices, which could be anywhere between 10, 20, I'm not sure exactly how many the 11th Circuit has. So while the decision stands, it's not over. It's not over till the bell rings, or whatever the saying is. It's still under, it might be reviewed, and even if it's not, there's reasons to believe that it might not apply in all situations. And then we have other jurisdictions, for example, in New York, that have completely gone against this finding. In New York, one of the judges dismissed, I think it was a group of 6 to 8 cases at the same time, basically saying, this is not a solid claim. There's no standing for this. There's no solid reasoning for this claim to think that sending a debtor's information to a mail vendor would be considered third-party disclosure, considering the entire environment of the debt collection ecosystem. but again, a lot of, everybody wants to move fast to react to this. And the general message we try to send is, hold on, let's see how this shakes out. There's no need to change your entire plan when it's just one circuit that had this decision and it's not even finalized yet. So sometimes that's the interesting part about being the attorneys in this industry, is telling our business partners, this is when you should go and move, and this is when you should pause. And having good partners that know that kind of a distinction is really, really vital, or else you can really spin your wheels with some of this stuff.
We transition now to the debt collection rule. It was pretty fun because the CFPB, I think, very much enjoys putting out press releases at 3:30 p.m. Eastern time on Fridays. And so about a week ago, was it last Friday? It might have been last Friday. There've been so much going on, it's all blurry in my head. I think it was last Friday. They came out and they said, guess what? The rule is actually going to take effect on November 30th of this year. The reason why they had to come out and tell us that was because 2 months ago, they're like, hey, do businesses need more time? Would you like an extra 60 or 90 days, say, to put the measures in place that you need to in order to be prepared for this rule to go into effect? We would like comments on this. And so the industry was like, what? So many people provided comments about whether or not they thought they would be ready. Fortunately for True Accord, we are in good shape. So we were fine with the November 30th effective date. But interestingly, in that press release, they also kind of alluded to the fact that, if there's anything in the rule that they want to change or amend or add later, they can do that, which they can. And I recently was at the RMAI Executive Summit and heard from Tom Paul, who used to run the debt collection rulemaking division. And he said 3 things he thinks are on the radar of the new CFPB. And I think it's important to mention them. Things that he thinks might change or be amended in the rule are perhaps an out-of-statute debt collection ban, perhaps bringing creditors into the fold of the FDCPA, which we knew the CFPB has been considering because during the rulemaking process, they asked for a lot of feedback on should this apply to first-party collections. And the other thing that he brought up was whether or not he believes that the CFPB will start to think about whether or not the call cap needs to be turned into a communications cap, right? So instead of a 7 calls per week call cap per account, having that be maybe a total, coming up with some total communications cap. So interesting things to be thinking about as we turn to the debt collection rule itself.
Great. Kelly, thank you so much for setting us up to talk even more about Regulation F. So I'm excited to move on to the next section of the webinar where we're going to take all of those great insights on this current moment and think about what exactly the people on our webinar today should be doing to get ready for Regulation F to take effect. So here is a preview of what's to come and some of the takeaways that Katie and Kelly will be sharing today. So let's start by talking about how Regulation F embraces technology and what does that mean? And I think, Katie, I'm going to be turning to you to tell us more about this.
Yeah, so as I'm sure it's been said loudly and on the rooftops, finally, there's some guidance on emailing and communicating with consumers through digital means. And of course, us at True Accord are like, yes, we've been doing this for a very, very long time. But it's the first time where you have a regulator issue some sort of a rule or law, if this is a rule, that gives the green light to these types of digital communications. The New York had one or has one in effect as well, but theirs is, as anybody who collects in New York knows, very, very restricted. Now it seems like there's this green light to use digital communication methods, including email, including SMS, including also any sort of digital method of communication that might not even be in existence yet. The CFPB itself said in the preamble of the rule document itself, which by the way is like 1,000 pages long, it's a little bit of a beast to get through. But they say, you know, we don't want to limit this just to email and SMS because they understand that communication methods might change in the future. So they left it open-ended, and they said, you know, we're going to provide these safe harbors here. Nothing here prohibits doing anything that might not fit within these four corners of the safe harbors, and nothing here prohibits applying similar philosophies to different forms of digital communication. So what does that mean for lending institutions? Well, for one, as we all know, many consumers these days prefer email over to phone outreach. And what we need to think about is how your organization can help your debt collection partners gather the information and data that they need to be able to seamlessly transition to a digital model with the debt collection agency. And this includes making sure you're capturing the specifics of how to contact the consumer. Make sure you're capturing the email address of the consumer in a way that you can then transition it to the actual debt collector. You know, that might, for some lenders, that might be a very simple thing, like, oh, it's just whatever we got, we send. For other lenders, the origination department might be different than the servicing department, than the department that goes to recoveries, and not all that information flows through all of those phases of the account's life. So it's important to make sure that you're going back and that information, so the email address, the cell phone number, if it's going to be for SMS, once we get, you know, we've got, they talk about Facebook messaging within the rule itself. Whatever it is that you're capturing, you want to make sure that you're capturing that data to enable your debt collection partner to use those channels by getting that data to the debt collection partner. And as I mentioned, you know, email is preferable to phone outreach. TrueAccord has been doing this for a long time. Consumers love the fact that we don't call them, and it's actually a very, this rule itself and its allowance of technology and the use of digital means of communications is humbly, Kelly and I think, a testament to TrueAccord's lobbying efforts in the whole rulemaking process. So I believe that OHAD served in the SBREFA period, the Small Business Review period. We've at TrueAccord have shared a lot of data about what we've learned about consumer preferences with the CFPB. There was, TrueAccord wrote a comment to the rule as well that addressed a lot of issues, and it's a real testament to those efforts that the rule essentially validates the business model that TrueAccord has been doing for a while. Oh, Kelly, I think you're on mute.
Yeah, totally on mute. And as a result, that's because my dog, of course, who I like occupied with a bone so that he would be totally happy during this entire webinar, decided to play with a squeak toy. And I was like, are you kidding me? Anyways, he's back to his bone now. So essentially, I think that one of the reasons why we don't have as much to do to prepare for the rule is because, you know, of all the efforts that were put in at the front end of the rulemaking process, so that the CFPB, when they came out with their final rule and we looked at their email provisions, it's almost identical to what we already have in place as it is, right? We already have an unsubscribe link on every email. We already, you know, are sending the email from a TrueAccord, you know, email domain. We already put in required communications, you know, a piece of information about the debt to trigger that consumer's, you know, knowledge. Oh, this email is pertaining to, you know, a particular account that I actually have. We have the dispute flow linked in an email so that, you know, consumers can very easily go and check out the dispute flow process, find out more information about the account, and determine whether or not they need more information and they want to dispute, or whether or not the information already exists there for them to see. So I think the biggest success that we saw in the rule was a little bit around the deliverability questions, right? So for convenient times or inconvenient times, the rule made very clear that just like mail, we don't know when the consumer receives the letter that we put in the mailbox. So similar for convenient times for email, when the email is sent, that is the time that you look at to determine, are you sending it within the 8 a.m. to 9 p.m. presumptively convenient times. So that was a really good outcome in the rule itself. And, of course, as it relates to, some sort of cap, I think the CFPB very clearly considered the fact that the email service providers control that themselves, right? If you are tagged as a spammer, you're not going to be able to deliver emails to consumers, and you're not going to be successful in your collection recovery process, right? So your deliverability strategy is critical. And if you are sending consumers too many emails in a given time and they choose to identify you as a spammer, that reputation is something that follows you, right? And so, that's why the CFPB didn't put a cap on emails, at least at this portion in the rule. And that's why no cap on emails is really required, because that that's monitored, by the email service providers and the consumers themselves. They have the control there. Finally, they didn't put any additional barriers up, around email. There is no consent required as it relates to email in the law, the federal law. There could be a separate discussion about New York, because New York has a provision in their law where if you're not capturing consent to email with the debt collector, you will need to capture consent as a debt collector to email in New York. But otherwise, for federal laws, CAN spam does not apply to debt collection. It applies to commercial messages. And e-sign does not apply to the initial communication. And there's good case law on that in a case called Green versus True Accord out of the very, liberal jurisdiction, Northern District of California. A judge in San Francisco made clear that you do not need a consumer's consent to send them the email containing the initial communication with the debt validation notice. And so, that's where Reg F came out, and True Accord couldn't be happier because it leaves us with very few things to have to do to make sure that we're ready on November 30th. So why don't we take a look at some of the things that we are putting into production so that we're ready to go?
Yeah, so one thing that Reg F requires is all of a sudden we have this new validation notice, which is that initial communication that we sent to the consumer, initial written communication. And all of a sudden, some new information is required that may not have been required before. So as, you've hopefully been preparing for this already, but if you haven't, just like some examples of what's all of a sudden going to be required is an itemization of the debt similar to what New York has, except now it's no longer just New York and no longer just the financial products as New York's rule kind of limits it to that. It's all of a sudden going to be nationwide. Some information you have to be sure that you're capturing for that are the itemization date, and that can be any number of dates. So for most institutions, it might be the charge-off date. And then again, just like in New York, you do the charge-off date and then the payments since charge-off, interest since charge-off, and fees since charge-off, or any other adjustments, and then what's the total balance right now. Some lenders, maybe some smaller lenders or fintechs, they might not have charge-off dates. So there are other options to use as the date, but it's important to start deciding which date you're going to use and make sure you're capturing the relevant information that's going to be associated with that date, so that when your debt collection partner begins using this new validation notice, they have all of that information to populate the letters, because sending that initial communication without all that information is just not going to work anymore after November 30. Some other stuff that's, Laura, if you could go back to the previous slide, I think I hopped over that real quick. Some of the other information that is new for the validation notice that it wasn't required by the FDCPA itself is, for example, all of a sudden you need to include the consumer's name and mailing address, which for regular, traditional debt collectors who use mail houses, sure, that might be something you include, but why do we need an address if we're communicating via email? Well, the CFPB says you do. And so if you are, for example, a lending institution that does primarily digital stuff, and you don't even collect the consumer's address, that might be something you consider to start collecting because it's going to be required. There's a requirement, which is more on our side, not on the lending institution side, for example, to include no longer just a sentence that, hey, you've got 30 days to dispute, that's your validation period. Now we have to specifically write down, here is when your validation period, your time to dispute expires. But of course at True Accord, we honor disputes that come even after that period. It's just, we have to now start calculating that and putting that in. I'm not going to go through all of these, and these slides, as Laura said, will be available later, but it's just some good food for thought that all of a sudden your debt collectors are going to need a lot more information than they did before. And the sooner you start, just like with the email or the digital communication things, making sure you're capturing the right data so that you can send it to your partner so that they can start right off the bat with all the information they need, that would be one of the best ways to prepare for this.
Great, thank you so much, Katie. We're gonna, Kelly, hand it back over to you. And again, just to reiterate, there's a lot of great information on these slides and we'll be sharing them afterwards, so you don't have to take furious notes right now. Kelly, I wonder if you can talk a little bit about maybe specifically how True Accord is, working to share this information and build internal compliance by working cross-functionally.
Yeah, absolutely. So this has been a real labor of love, I think, and I don't know if everyone enjoys it as much as, say, I do or Katie does. I know that she mentioned the debt collection rule. I keep it lovingly close to me. There's two. There's not just one, there's two. I'm sure if you've seen me talk about it before, I wave it around quite frequently. And, one of the things really was spending a lot of time with this rule and making sure to read it twice, because the devil is really in the details. And so even though you have, the short number of pages, probably 20 pages of the 1,000 that actually have the rule in it, and like, okay, here's step one, here's step two, right? The description that came before and that came after is really where you found how the CFPB was actually going to apply it. And this is important when you're thinking about how you're going to operationalize something, and when you're sitting down with your product and your project teams to kind of map out, all right, here are the requirements that we need to get into our system. What is a way that we can do this that's going to, be easy to scale, be convenient for our clients? And of course, this started when the rule came out, which was last November and December, and followed by furious memos and then a lot of working together to kind of map things out, right? Because when you're talking about, say, inconvenient contact times, you have to really think about and work through problems related to, say, time zone, for example, because this is the first time where the CFPB made clear that if you do not know the consumer's location, then you must presume the consumer is in any location that you have evidence to believe they're in, right? So if you have an area code that is a different location from a zip code, which is like me, I'm a military spouse, I move around a bunch, I have a California area code on my cell phone, and I have a Virginia zip code for my address. So if you don't actually know where I'm physically present, you have to presume I'm in both locations starting November 30th. And so, you have to think through, all right, well, what if is your client passing you a time zone that is the time zone of the consumer? Are they passing it in Central Standard Time? Are they passing it in Pacific? How are they communicating that time zone to you? And in what time zone does your system speak, right? So you have to work through, all of those sort of things when you are thinking about trying to operationalize this, and you're working hand in hand with your partners and your engineers and your programmers to try and make it as code-based as possible, because the more opportunity you have to put those, systemic controls into your systems so that there is a minimal opportunity for error, the better off you're going to be in the long run. So that's essentially the long and short of it. And we started by making presentations on this for our clients very early on. I think February is when we put out the first set of slides about it. And a lot of it is important for communication because of what Katie was showing as it relates to the new information that we have to have. And while some of it is information that maybe you're gathering already for New York, it's one thing when you're gathering it for one state, but it's another when you have to gather it for, all the rest of the states. And, fortunately, as the devil is in the details, we found, on page 102, some super helpful language for our clients, and after discussing actually with a friend, Jordan Dinos, who helped us work through these provisions, it's very clear that the CFPB was thinking about businesses and operationalizing these rules. And so they did make clear in the rule that, as it relates to inconvenient time, we are not required, and creditors are not required to pass inconvenient time information on to each and every debt collector. That is not a requirement in this final rule. And additionally, which is also very helpful for digital communication, the rule makes clear that a debt collector is not bound by a request that a consumer made to a prior debt collector. So if a consumer told a prior debt collector, I don't want to communicate with you by text message, that doesn't apply to the next debt collector. Same thing with email. They said, I don't want to communicate with you by email, to a different debt collector, and then it comes to True Record. That doesn't apply to True Record's collection efforts, because the Bureau believes that a person who might not want to communicate by email with one debt collector might change their mind and want to communicate with a different company, in email, just based on, I think the Bureau said specifically, they might not object to another debt collector's use of that same medium. And that's on page 335 of the rule. So there's some really good nuggets throughout the rule. It just took a while and a couple reads to make sure that you were finding them. And they're very beneficial, not only to True Record, but also to our clients as we're trying to operationalize some of these things in a manner that makes sense for the industry and for our businesses.
Great. Kelly, thank you so much. That was a lot of wonderful information to digest. Let's kind of sum things up by looking at some quick lightning round summary points. So just to sum up for everyone on the call, we've been talking a lot about November 30th. That's the date that Regulation F goes into effect, and it is sooner than you think. I hope that everyone is already preparing, capturing the information they need to capture, or thinking about their information gathering processes and making sure that they're compliant. As Kelly just said, it's a great point. The devil is in the details of Regulation F. Your legal and compliance team should not just be, doing this as like this should be their, full-time. They should be the engine that's driving compliance throughout the organization. And that means, working cross-functionally with product to make sure that everything in the regulation is compliant through, ideally, as Kelly said, in code. And finally, as a final point, just the top-notch legal and compliance, like our speakers today, it is difficult to build on your own. And we would, encourage basically every lending organization to look for partners who can help set you up for long-term success with, their wealth of knowledge. So I am so happy with the insights that you shared today. Thank you so much, Kelly and Katie. We're now going to transition into Q&A. So everyone here, please shoot us your questions. Again, you can use both the chat function and the Q&A function. And we'll give everyone just a moment to write down their thoughts.
I don't know, Katie, if you've had any questions about the rule lately. one of the things that we've been thinking about with our content design team is how to make that initial communication one that's easy to read on your mobile device, because we know from our research that most consumers prefer to communicate with their mobile phones, and they do read their emails on their mobile phones. And so we've been taking advantage of the provision that makes clear that all of that information, and including the information in red on that slide that's additional and wasn't required to be on the initial communication before, that information can be included in hyperlinks. So, you know, again, just a happy nod to True Accord. So our dispute hyperlink satisfies a lot of the prompt questions that you see in the model notice. And so involves minimal changes on our part. So appreciate that from the CFPB, that they recognize that hyperlinks is an easy way to allow consumers to go select and then see more of what they're interested in.
Any questions? We'll give one more minute. Feel free to type them in the chat box. You can also follow up later. I'll be sending you emails after this to share the information. So do a little countdown in my head before we close it off.
Another thing that I was excited about in the rule, I know you keep asking, was the nod to social media, right? Because a lot of the FDCPA was born in 1977, so it's like 44 years old, and didn't really reference specifically email or text messages. And so, you know, folks were looking for those modern communication, digital communication things in this rule. They talk about email, they talk about text message, they talk about Facebook and social media, but that's about it. But the communication term, that definition hasn't changed, and it's still broad. It's anytime you're conveying information about a debt, you know, that is going to be a debt collection communication, and then the FDCPA is going to apply to that communication. But, you know, again, it made clear that our practices that we already have in place with consumers who like to use social media to communicate are certainly good ways to communicate to consumers, as long as you're doing so in a manner that is as private as possible, right? We have consumers who will reach out to us publicly on Twitter and say, hey, how do I cancel my payment today, right? We need to be able to respond to those consumers. So we have policies in place to do so. There's a question.
Yes, there's two questions actually. So there's in the chat the question about text messages, and then in the Q&A we have a question about any specific differences for healthcare organizations that are thinking about Regulation F going into effect. So feel free to, we'll get to both of them, and feel free to go ahead whichever one you want to first.
So I'll start with the healthcare one, and Kelly, maybe you can append my answer after I give it. So the interesting thing about the rule is that it doesn't differentiate between financial services and healthcare. There's a open question about whether the CFPB can govern healthcare organizations. I think the conservative approach is that when it comes to financing healthcare, it does. There are some considerations that healthcare organizations have to take into thought as they prepare. One example is the itemization date. The typical financial services itemization date that's used is, as I mentioned earlier, charge off. That probably doesn't apply to healthcare, so you're going to have to think of another date. Typically, I believe it's date of service, but there are enumerated dates that you're going to need for that. There are obviously HIPAA considerations for healthcare as well. So, how do you make sure that that initial communication, including all the information you're going to include, doesn't trip any HIPAA concerns? Which, if you include just the minimal what's needed, it shouldn't. Kelly, do you have anything else that healthcare organizations should think about?
No, I think that is an excellent answer. And I will take the second question, which relates to confirm there are no restrictions on text messages to consumers from first-party lenders, correct? So the debt collection rule at this time does not apply to first-party lenders who are sending text messages to their consumers, right? If the debt is defaulted, then it will apply. And there are some restrictions or some interesting provisions related to text messaging in the rule that you would want to be aware of. So for example, they put in a safe harbor provision if you are sending a text message to someone and it turns out to be a third party. You don't want to disclose a debt to a third party. That's a no-no under the FDCPA. And so there is a safe harbor provision that you can avail yourself of that's outlined in the rule that requires you to do, telephone scrubbing and making sure that you're communicating with this consumer within a, regular 60-day sort of cadence. Also, not included in the rule is the TCPA. The TCPA does apply to text messages that are sent using automated telephone dialing services. So there's that whole thing. But the TCPA is a separate and distinct area of law from the FDCPA. So technically, under the rule, if you are talking about first party pre-defaulted communications, FDCPA does not apply.
Well, thank you.
We had another question.
Yeah, there's one more question, and I think we'll probably have to wrap after this one, but yes, about the standardization demand letter.
Yeah, so I'll start the answer to this, and then Katie, you can actually have, so the FDCPA debt collection rule, Regulation F, as it's sometimes referred to, did put on Appendix B, a model form, did draft a letter. And if you're, as an initial demand letter, and this form, if your letter or your emails are substantially similar, it is a safe harbor for making sure that you have incorporated all of the information that is required to be in that initial communication. The CFPB is always thinking about standards and standard communications with consumers. They have a whole testing division that sends out all kinds of notices to determine whether or not the consumers understand the notice, need the notice, have value in the notice. They did a lot of testing around out of statute disclosures, for example, and decided not to prescribe a safe harbor out of statute notice because they found that consumers found that the notices that they were testing were confusing and couldn't land on language that they liked. So they didn't end up putting that in the rule. But there is, possibility that the CFPB will always attempt to create some sort of standard as it relates to other things such as notice to cure letters. Notice to cure letters, though, do typically tend to fall under state law requirements. So I'm not sure that the CFPB would launch into that particular area as it is governed exclusively by the state laws relating to whether or not there is a notice to cure requirement. And then all the state law stuff, the CFPB talks about how you can ensure that you are meeting the additional state law requirements that you still need to meet by putting that information on your initial communication on the front or on the back, wherever you can make it fit in light of all of the verbiage that needs to be on there now.
Cool. Thank you, Kelly. It looks like we have one more question in the Q&A if you want to take a look. And then I think after that we will wrap up for the day.
If your agency does not accept disputes online, would you mind clarifying to the audience that if your agency does not accept disputes online, then you may or may not want to include it on the model letter. Also, there is not a requirement to create an online process, is there? Okay, so first of all, there is no requirement that you create an online dispute process. That is not a requirement of the law. The requirement does have a prompt, so you are required to let the consumer know what their dispute rights are. And it's a section called How Can You Dispute This Debt? And they basically changed around to make it more friendly and easy to understand. Call or write to us by such and such a date to dispute all or part of the debt, blah, 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 blah. So with that information, they also created a tear-off portion of the letter that says, how do you want to respond? And then it gives a couple of options. I want to dispute this debt. I want to pay. I've enclosed this amount. I want you to send me the name and address of the original creditor. And so you're not required to do this online, but because TrueRecord communicates with consumers primarily online, we have this already built out online. And it's good news that we do, because it's required to be there starting November 30th. And we already have it there. So